Dear followers, as I promised you in my story on Instagram, as I received several questions from our client regarding to the obligation and responsibility between the developer and investors in real estate, I decided to gather all these common questions and answer it in this video. The first very common question: is the developer allowed to postpone or delay the date of property delivery? And if yes, for how long he can do so? The answer is according to the Federal UEE Law number 2/2021, article number 56, that mentioned clearly that the purchaser has a right to file a case to the competent court to claim the damages without the rights to terminate the contract on the following circumstances: if the developer delayed the delivery of the property and giving the completion certificates for a time less than 6 months and not more than 1 year from the agreed delivery time. Based on that, there is a legal obligation against the developer of delaying, but it gives only the rights to the purchaser or investors to ask for a compensation if the delay between 6 months up to 1 year. And if it is more than this is something else. So if it is more than 1 year, it's going to be different situation. If the delay meant more than 1 year, it gives the rights to purchaser to ask for contract termination. Second question: what if the developer changed the size of the properties? Does that gives the purchaser or the investor the rights to terminate the contract? The answer is according to the article 52.3. It mentioned clearly that the purchaser has the rights to revoke the contract and ask for a compensation in case the sizing of the properties becomes more than 20% of the total sizing of the properties. But if it is less, that not considered a major violation of the developer, which could lead to revoke the contract with a compensation. Third question: if the developer decided to change the specification of the property by his own will without consulting or taking the written approval of the purchaser, the question is, does the purchaser have the right to revoke or terminate the contract? The answer is, according to the same law article number 55.2, the major difference in the specification, if the developer did that without getting a written approval of the purchaser, it becomes different than what it was mentioned in the purchase agreement. He has no right, because the law gives the rights to the purchaser to request the court to terminate the contract. I'm going to give you an example for such a major specification. The purpose of the properties. If it's like a hotel apartment and then the developer transferred it by his own will to a residency apartment, this is considering a major specification. I hope I gave you today useful information. My name is Ahmed Abdulshafe, Senior Managing Partner of AAA Amira Sakhr Advocates and AAA Ahmed Abdulshafe Advocates in Egypt. Don't forget to subscribe and press like, activate the ring to be able to receive the new videos. Thank you for watching.